everybody. So, of course, V Radio, the gentleman that I made the base my Cal Rittenhouse video off of, he made a video about Cal Rittenhouse, and it was in support of Cal Rittenhouse. I responded to that video, and I think that was a mistake, and I'll get into why. And of course, he responded to my response to that video. So now this video is partly going to be in response to his response to me. So the reason I think this is a mistake on my part is because I don't want my videos to be controlled by someone else. And what I mean by that is that even though both parties may be respectful and they may be civil, you could end up in a situation where you're both responding after each other back, and you're going back and forth and back and forth. For me, that's not something that I really want to do. I kind of want to do independent content. I kind of want to do content based on what I feel, or I want to blog about, so I want to vlog rather about things that I want to vlog about, and I don't want to really get caught up into kind of vlog wars, if you will. So this is going to be my last response to V Radio's video. And I think when I initially responded to his first video, I thought the first video was extremely good in the way that it was organized, the amount of attention to detail that was put into it. I thought it was really good. I just thought that some of the arguments were wrong, if you will. So now he's responded to my video, and I'm just coming back, and I'm going to respond to some of the things that he said. I'm not going to make a super long video responding to every little thing that he said, because I don't feel that I have to. And I don't think that I need to, because some of it really doesn't warrant a response. No disrespect to him, but I'm going to respond to some of it. So the first thing I'm going to respond to is where he talks about case law. I'm going to play his video. Joseph Rosenbaum is unarmed. Joseph Rosenbaum is unarmed. So how in the world are you going to claim self-defense on a man that didn't have a gun? So
it's entirely possible for somebody who is unarmed to attempt to kill you. And you asked for case law about this, so I went and dug some up. The case is called, there's actually two different cases with similar situations, but you have State versus, Carol, actually, I'm sorry, these are the same case. Carol D. Watkins, I have just two different documents on them. In the case of Carol Watkins, basically a guy had a gun in his hand. Somebody had assaulted him earlier, returned to try to assault him again. And in the course of it, he pulled the gun on the guy, asked him to back away. The guy ran up, grabbed his gun, and then they wrestled over it. The gun went off, and he killed the guy. Now, his initial, basically it says here, Watkins testified that he did not allow Malone to take the gun because he thought Malone would shoot him with it. He described his action of grabbing Malone's wrist to keep control of the gun as instinctive. So initially this case went to court, and they denied his, they charged him with second-degree homicide, and they initially denied his case for self-defense. Now, he was arguing a case of self-defense, saying that the gun went off accidentally, but during the appeal, they pointed out that according to the statutes, an affirmative defense is defined in Black's Law Dictionary as a defendant's assertion raising new facts and arguments that, if true, will defeat the plaintiff's or prosecution's claim, even if all allegations in the complaint are true. Black's Law Dictionary, emphasis added, to illustrate, a defendant who successfully raises the affirmative defense of perfect self-defense may be found not guilty, even if the state proves that the defendant killed a person intentionally. So the reason that was necessary to point out is that what they pointed out is that even if he had, even if he did not accidentally kill the person in this case, he still would have been innocent, because he didn't have to kill the guy accidentally for that to work. Basically, you have a same scenario. Guy's attacking you. He's grabbing your gun, and so you still have the right to defend yourself. That doesn't just vanish. So I also, So let me stop it right there. So he
And no disrespect to him, absolutely no disrespect to him at all. And I'm going to respectfully say that he should probably reread that case. I read that case, right? And we're going to get into it in a minute. But first off, that case does not justify shooting an unarmed man. It doesn't. So let me just switch gears here and we'll get into the case. This case has nothing to do with the justification of the shooting of an armed man. Nothing to do with it. They mention self-defense and they mention justifiable homicide, but this case has absolutely nothing to do with justifying shooting an unarmed man. Watkins' defense is that the gun went off accidentally. That's his defense. In the heat of the moment, the gun went off. That's his defense. And this type of defense is not going to apply to Kyle Rittenhouse. And I'm going to get into why a little bit later. But first, let me just see if I can just kind of navigate this case, because it's a pretty long case. It's a pretty long read, so to speak. But I want to assure you that I think Radio V is misapplying this case. So this is the part that Radio V reads, right? And this part is taken out of context because they're just talking about defenses in general, right? So to really get the context, you have to read the paragraph before it. It goes, the parties disagree as to whether accident is truly an affirmative defense. Watkins contends that the accident is an affirmative defense and that it works as any other affirmative defense once the accused produces some evidence of the accident. The state must disprove accident beyond a reasonable doubt. Conversely, the state asserts the accident is not an affirmative defense, but rather operates only to negative the elements of intentional or reckless or criminally neglect conduct. So that's the part before Radio V reads. And you have to understand that they are really just talking about what an affirmative defense is. And in the course of talking about what an affirmative defense is, they mention justifiable homicide, basically. And they're not saying that, even in this case, that, the gentleman, Watkins, was justified by shooting Malone. So this is the part that Radio V reads. He goes, we conclude that the accident is not a true affirmative defense. An affirmative defense is defined in Black's Law Dictionary as a defendant's assertion raising new facts and arguments that, if true, will defeat the plaintiff's or prosecution's claim, even if all allegations in the complaint are true. Black's Law Dictionary 151, 1999. To illustrate, a defendant must successfully raise the affirmative defense of perfect self-defense may be found not guilty, even if the state proves that the defendant killed a person intentionally. This has nothing to do with the actual case. They're just trying to tell you what an affirmative defense is. The actual case is whether or not this guy accidentally killed the other guy. That's it. Whether Watkins accidentally killed Malone. So I think he needs to go back and read this case. And then, and you've already heard me read the section where they talk about the accident, but I'm just going to continue to read. It says, if a person kills another by accident, the killing could not have been intentional. As a court of appeals has stated, all reasonable persons know that intent is the antithesis of accident. So, again, this is not going to apply for Kyle Rittenhouse's situation, because what people are trying to argue, they're trying to argue that Rosenbaum reached for Kyle's gun, and that basically constitutes a self-defense. Based on this case law, it doesn't. Because when you read this case law, you'll see that there's an actual struggle for the gun. Or at least that's what he's alleging. When you watch the videos, there's no actual struggle for the gun. You see the guy run towards Kyle Rittenhouse, and then Kyle Rittenhouse turns around and shoots him. Now, they're going to argue that he reached for the gun, but was there a struggle for the gun? Obviously, there wasn't a struggle for the gun. Anyone watching the videos, and I'll play that video again later. Actually, I won't even play it because I'm tired of searching for the video to play. I have other videos that I'm going to play for you. But you can see in those videos that there is absolutely no struggle for the gun. It doesn't even look like Rosenbaum even touches the gun. And even the witness says he reaches for the gun. The witness doesn't say he grabs a gun and they're fighting for it and then Cal shoots him. He doesn't say that. So nothing in this case law is going to apply to Cal's situation. Nothing in this case law is going to get Cal out of jail. Absolutely nothing. And there's actually some other parts that I wanted to show to you. That one of the things I actually wanted to show is that the guy is actually losing the case. First, the circuit court did not provide a clear analysis. So this is the reason why the Supreme Court of Wisconsin basically pushed the court back down to circuit court, is because they say, first, the circuit court did not provide a clear analysis of his thinking on his legal issues surrounding self-defense and accident. So they're essentially saying the issue of self-defense was never tried. It was never really properly heard. That's what they're saying. So because of that, they're pushing it back down to the circuit court so it can be reheard. But even with that, even by pushing it back down to circuit court, more than likely he's going to end up, or he did end up with essentially the same charge. It is not clear from the record exactly how the court evaluated the defendant's accidental defense at trial. Accident is not mentioned in the court's oral decision. And then another reason they pushed it back down to circuit court for another hearing is that Watkin complained that he had ineffective counsel. So that's always a defense. And there's something else that's interesting that I think is actually going to hurt Kyle. And I'm going to point it out in another video, but I'm just going to read it here. Well, it's going to be in this same video, but I want to show a video clip before I actually read it. It goes, the doctrine that when one is where he has a right to be and does not create a danger by his own wrongful conduct, he may stand his ground. If assailed by another, and in the case of his honestly and reasonably believing himself to be in imminent danger of losing his life or receiving some great bodily harm at the hands of such other, he may use such means as presently to him reasonably seem necessary to avert the impending danger, even to taking the life of his assailant. This is interesting because I'm going to tell you up front that this section is about the common law rule of retreat. And I'm not actually going to address the common law rule of retreat. What I'm actually curious about is whether or not you have a right to self-defense in certain situations, right? So it basically says the doctrine that when one is where he has a right to be and does not create a danger by his own wrongful conduct. So let's think about this for a second.
Had he said anything about the riots, Wendy, that had gone on a few nights before?
No one should have been at the riots. It's a horrible thing what happened. And it's just hard on everybody. No one shouldn't have been there. I mean, if they were going to protest, they should have done it peacefully.
Should Kyle have been there, Wendy? Should Kyle have been there, Wendy? Should Kyle have been there, Wendy?
But the problem with this is that he's introducing a gun into the protest. And I think in the other videos, I mentioned that he had all these strikes against him because of the doctrine of unclean hands. And there's also another legal maximum says that you can't take advantage of your own wrong. You can't use your own wrong as an excuse to get out of a crime. Problem in this situation is that he's bringing a gun to these protests. And first off, he's underage and he doesn't have a right to have a gun. Second, he wasn't a part of the militia. And we're going to get into why he wasn't a part of the militia later. And then third, he wasn't lawfully protecting property. He didn't have a license to act as a security professional, which we're going to get into later. We're going to get into all those later. In that video, a judge is actually speaking. The judge is going to tactfully introduce this concept of whether or not Cal should have been there. And this is going to be important because when the prosecutors go to the jury, they're probably going to argue that he shouldn't have been there. He had the right to be there, but he shouldn't have been there, and he damn sure shouldn't have been there with the gun. Trust me, this kid is going to lose. He's going to lose for sure. 100% he's going to lose. And it's going to become apparent why he's going to lose as we get later into, this video. So let me just move on. And then it goes on to say Ms. Watkins did not have to introduce a gun to this event. Cal didn't have to introduce a gun to this event. And people are saying, well, what would have happened if Cal didn't have the gun? Well, you have to understand the chain of events that occurred happened because Cal had a gun. He was there with a gun and he was pissing people off, acting like he was in there with some official capacity. That's why the chain of events occurred. Had Cal just appeared and he didn't have a gun and he was against the people who were protesting, he just stayed with the people who were against the protesters, everything would have been fine. I don't think he would have drawn any attention without a gun. It would have never happened. At the most, what would have happened, in my opinion, is that there would have just been a fist fight and that would have been the end of it. Even when Rosenbaum assaulted him, I think at the end of the day, there would have been a fist fight and that would have been the end of it. Now, can someone kill you with their bare hands? Yeah, someone can. But for me, I don't really see that as a realistic possibility. It can happen, but the chances of something like that happen is so far out there. It'd be like the chance of, getting hit with lightning or something like that. That's my opinion. And the reason I say this is because I grew up and I was in a lot of fights as a kid. I was in a lot of fights in my teenage years. And I even took I was even involved in a lot of contact sports like, Taekwondo and martial arts and things like that. And I just don't see how a person can, kill you that easily. It's just not something that's realistic. And I'm not saying it can't happen. Yeah, it can happen, but it's not the norm. The norm is not for a guy to kill you with his bare hands unless he's the Incredible Hulk or he's a werewolf or a vampire. In that case, yeah, shoot him. But if he's an Incredible Hulk, the bullets aren't going to kill him. They're just going to bounce off of him. So shooting an unarmed man just doesn't make sense to me. It will never make sense to me. And I just can't, my conscience just won't allow me to accept that Cal should just get off because he got into a fight. He was about to fight an unarmed man and he chose to shoot him. Cal brought the gun to the protest. He didn't have to bring the gun to the protest. He could have, and even if he did bring the gun to protest, he could have brought some bullets that basically would have, what do you call it? There are certain bullets that you put in the gun that don't kill a person, like bird pellets or something like that. He could have bought bullets that could have maimed instead of killing, right? Or he could have bought pepper spray. Or he could have bought mace. He could have brought mace to the event. He could have brought anything to the event, but he chose to bring a gun. And when he brought that gun, he specifically says, we don't have non-lethal. And I'm not taking that out of context. He's basically saying, if I get into a fight, I'm going to kill a guy. That's what he's saying. I'm not saying that he's running around shooting into crowds. I'm not saying he's running around sniping innocent protesters. That's not what I'm saying. What I'm saying is that he didn't bring mace, right? If somebody attacks him, he sprays him in the face with mace. He didn't bring, maybe a bat or something like that. If somebody attacks him, he beats him with a bat. No, he brought a gun. and he intended to kill whoever he got in a confrontation with. And we know that because of his statements. We don't have non-lethal. There's plenty of things that he could have brought, but he chose to bring a gun. Please. And the most important thing about this case, I want to point out, is that Watkins didn't necessarily win this case, right? It says, in this case, it is far from clear whether a new trial will result in a different verdict or in precisely the same verdict previously rendered. So the only thing that's happened here is that they have basically pushed this case back down to circuit court for it to be retried, just so they can hear the argument of accidental shooting, that the shooting was an accident. That's the only thing that's happened here. When you read the case, it's clear that they don't believe that he used the appropriate amount of force. And when you read this case, it's even clear that they don't even believe it was an accident. But because we're talking about the law and they want everything to be done by the book, they're pushing this case back down to circuit court just so he can exhaust his claim of accidental homicide, right? But when you read the case, it's evident that they don't believe it was an accident. It's evident that they believe he used an inappropriate amount of force. So, in my opinion, this guy probably didn't even win this case. So anyway, let's move on.